mostly on climate issues regarding Act 250. My testimony today is focused on the administration and the VNRC draft that the committee is considering that was presented on January 14th of 2020. Certainly Act 250 has a very unique and visionary role and continues to be a valuable asset to Vermont. At its core, Act 250 focuses on statewide impacts of a development proposal and recognizes that what one does on the land affects the natural and community resources throughout the state. It has 10 very common sense criteria, and while sometimes another permit can satisfy those criteria, and that's used, there are other parts of Act 250 for which there is no other permit, and Act 250 is the only opportunity to review those impacts. I think a hallmark of Act 250 has been its openness to community and citizen participation. It's often an effective means for citizens to engage with what's happening in their community. And it also provides an opportunity for feedback and a venue that helps bring developers and communities together in a way that focuses on the bigger impacts of proposals that may come forward. I talked briefly about some of the current problems. I don't want to delve into this too much. Many have already been identified. I've reviewed a lot of the testimony you've already heard. I don't want to repeat any of that. I guess I would simply like to highlight that it has, for a while, been difficult for citizens to participate in Act 250. It certainly can be an expensive process, a lengthy process, and an uncertain process. And while businesses may say the same about the Act 250 process, they're at least guaranteed a seat at the table, which citizens are not. There's also, in general, a lack of representation of the public interest in Act 250 proceedings. And in many circumstances, unless members of the public participate in Act 250, there is either limited or no evidence on certain impacts on the criteria. I'd now like to talk about 4 or 5 broad topics, and I provided some fairly specific recommendations in the written materials that I presented, which is on the screen as well and available. And I'll go through each of them. I would start with the Enhanced Natural Resources Board, though I understand that the committee took a vote or had a discussion about this yesterday, so I won't go into this too much. Certainly an enhanced board is a workable structure that one could work with, but I think regardless of the structure that the committee chooses to move to advance, some changes would be needed. And those would include giving the commissioners full voting rights, local commissioners full voting rights. As in the VNRC and administration draft, they would be limited to just voting on factual issues, and to provide pro se participants with some access to technical and legal expertise to really enhance their ability to participate in the process. And I think those are the changes that would be needed regardless of the structure of whether you continue with the district commission structure or have an Enhanced Natural Resource Board structure. I'd next like to turn to the exemptions and highlight that there's a number of new exemptions in the proposal, and none of them really add value to advancing the Act 250 goals. There are many exemptions already in Act 250. I actually did a review from a few years ago, and I think both Legislative Council did a review and CLF did its own independent review a couple of years ago, and found at least 35 statutory exemptions already in place. And that doesn't include exemptions that have come about through case law as well. One way to address the exemptions and to avoid just continuing to create exemptions to Act 250, which really undermines the value that Act 250 would provide, would be to replace exemptions with rebuttable presumptions. This would allow continued review of a large development proposal and assurance that those projects are aligned with state land use goals and criteria. And creating a rebuttable presumption, if a project is so good or has so few impacts that it should be able to get an exemption, it should also be able to get an Act 250 permit. It should be able to show that it doesn't have the broader impacts that might be detrimental to the community or the environment.
Can you help us understand, by way of an example, an existing exemption and how that would work, or what can?
Well, sure, so a proposed one of the proposed exemptions is, sort of some of the designated areas. You would no longer need Act 250 permit for those. And there are currently exemptions for priority housing projects in some designated areas. So those projects, a project in those areas do not, with an exemption, they never file for an Act 250 permit. If instead of being an exemption, it would be a presumption, they would still file an Act 250 permit. I would still file for the permit. They would be presumed to have satisfied the criteria. And if somebody thinks, well, no, they really don't, there are, air quality impacts to this proposed development. There are specific impacts on any one of their criteria. That person or agency could come forward and say, you shouldn't just accept this as an automatic, approval. You should review these particular impacts. So that's the difference between a presumption, which would say, unless somebody comes forward and says there's a problem with this, it would get the permit, instead of an exemption, which just says you never even need to apply for the permit.
And you're proposing to apply that across all of the existing exemptions and the newly proposed ones?
Certainly at least the newly proposed ones. I think it could also be applied to, I haven't actually reviewed all of the existing exemptions, but it might be worthwhile to take a look at the existing exemptions and see if any of those would also be better suited to be a presumption instead of an actual exemption. Because again, the accepting that Act 250 starts off providing value and reviewing the community and environmental impacts of large development projects. Creating exemptions just undermines that goal.
Representative McCullough.
Question, if you will, Sandra, about rebuttable presumptions. My understanding is when, let's use the example that you did, and Jim McCullough comes along and says, wait, this is going to have a huge air quality issue. So now there is this rebuttable presumption that would be considered at my expense. Yes?
Yes.
Ouch. And would you say that rebuttable presumptions are a significant stumbling block to the citizenry in their ability to protect what they're concerned about?
It certainly could be. And there are ways to structure presumptions. Presumptions are used in law in many circumstances, and you can structure a presumption so that if anybody comes forward, if Mr. McCullough comes forward and says, I think this has an air quality impact, that would automatically rebut the presumption, and then the proponent would have to come forward and show why they've met that. So it wouldn't, in that circumstance, it wouldn't fall on you.
If we
If
laid
you
it
structured
out
it
that way.
If you laid it out that way.
Right.
Or, I mean, another means of doing it is you come forward and the presumption provides some evidence, and then it falls on person opposing it to meet a higher burden to address that. And you can look at depending on how you want to do that. But again, contrasting that with an exemption, Mr. McCullough has no opportunity to come in and address the air quality impacts of a proposed development.
Yep, thank you.
The new exemptions, as I was looking at the proposal, talk about the transportation and involved land, the new neighborhood development areas, the expanded hours for forest enterprises, and the reduced agricultural soils mitigation. And all of those reduce protections for communities and natural resources, and also reduce the opportunity for public engagement. I'd next like to turn a little to the rulemaking provisions of the proposal, and suggest that the rulemaking authority in the draft is overly broad. The new board could effectively eliminate criteria simply by creating very broad rules, or for example, defining many projects as minor that one would otherwise think of as major, or allowing projects to be defined such that they only require notice and aren't even, are sort of a step even below what a minor proposal would be. And this would effectively eliminate review and create new exemptions. And the recommendation here would be to narrow the rulemaking to make sure it's not too broad. And that could include making sure that existing precedent is applied to substantive criteria, or provide direction in some sort of guardrails over what's a major, what's a minor, and what sort of proposals would be allowed to proceed only with notice.
Can you remind us, where is this, the rulemaking authority? And you're talking about in the joint proposal?
In the joint proposal. Gee, I put down page numbers for all of them except the rulemaking. I'll double check and get back to you on that one. I'd like to turn to some of the new criteria or some of the changes to the criteria that's in the proposal. And certainly the intent behind many of the new criteria is helpful in filling in some gaps, whether it's on highway interchanges or ridge lines, river corridors, or new roads. But as drafted, I'm concerned that many of them could have little additional value, as there are ways to avoid their application in many situations. As written, they don't really provide any new protections, they may seem to provide protections, but in reality they don't. So the criteria, I think, should be tighter and avoid that language that would limit their application. And I provided some, language recommendations for each of these. I'll briefly go through them. On new roads, it exempts forest and agricultural roads, and those could later be used for development going forward. It's also confusing. There's some limiting provisions after the first sentence or so about the new roads that would limit the application of Act 250 to them. So again, this would be what's counted as development, what would be reviewed under Act 250. I think it would be better to lay it out as a very simple, construction or improvement of a new road. It falls within Act 250 and state it that way. For ridge lines, the addition to the definition of development I think is good. It can unfortunately be limited in scope and application by procedures that may be developed that would classify as minor developments, anything less than, to the extreme, anything less than 20 houses on a ridge line is a minor development. That would certainly limit the applicability of review for development on ridge lines. I think my suggestion for that would be to require all ridge line development to be classified as a major development project. On interchanges, and I think it's very helpful to focus on interchanges. There's been a number of Act 250 cases concerning development at highway interchanges, which are susceptible to development, and it's good to provide review of that. The limitations, however, that are as drafted would allow the Regional Planning Commission to make a determination, and effectively allows the Regional Planning Commission to create an exemption to an Act 250 standard. So it replaces Act 250 review with Regional Planning Commission planning, and in fact both are needed. Certainly Regional Planning Commission planning is important and is needed and is very helpful in making sure that land uses move forward aligned with what the goals of the municipality and the region, but that doesn't replace Act 250 review. So I think if you just keep the first part of that language to make it clear that the area around the interchange is subject to Act 250 review, that would be helpful. On forest blocks, the new section would allow mitigation in all circumstances. This effectively means that no permit could ever be denied, or would ever be denied, based on an undue adverse impact to forest blocks, connecting habitat, or rare and irreplaceable natural areas. The experience where mitigation has been allowed for other criteria, it's often jumped to fairly quickly. Mitigation, despite some precedent that says mitigation should always be used as a last resort, it's often used in many circumstances, and I think that there should at a minimum eliminate the provision that would automatically allow it in all circumstances, and include within the criteria that a permit could be denied for an undue adverse impact on forest blocks. Moving on to the new climate change criteria, I think this language, it's unclear how it would be applied or whether the permit could be denied or conditioned for failure to follow this. Certainly the added provisions are good. They're fairly limited in concept and scope, but they're all good measures, but they should be more clearly required. Otherwise, it could be the sort of criteria where a proponent could simply check the box and say it's done without any actual review that this is happening. So it should be required, in order to get the permit, you should be required to show that the applicant demonstrates that these provisions are met. Next, I'd like to look at the standing provisions, and this really affects the ability of citizens to participate in Act 250 proceedings. The current law is very restrictive. It's very restrictive requirements on citizens' ability to participate. Citizens can and have been locked out of Act 250 process, or they can participate, but they could have no right to appeal. And it should not be more difficult to participate in Act 250 proceedings than it is to participate either in court proceedings or in Public Utility Commission proceedings. Yet that's the situation that we have now. The recommendation here is to eliminate the particularized interest standing requirement that's currently in law and replace that with what is basically Article 3 standing, a requirement that says you need to have an interest that could be affected by an act or decision of the commission or board, with whatever. That would put it on par with any court proceeding and would put it on par with other agency proceedings going forward, and would allow citizens greater access to Act 250. Similarly, I think it's important to enhance the access to technical expertise and allow the board or the commission or entity responsible for representing the public to have broad access to technical expertise. There are bill-back provisions in the proposed draft, but those are too narrow because they would allow the governor, for any reason at all, to curtail bill-back and in that way curtail access to technical expertise that would be valuable in evaluating the proposed permit application. And the recommendation on that language is simply to remove the part of that would allow the governor to deny that for any reason. Next, I'd like to address the representation of the public interest. There's currently no entity that's specifically charged with or responsible for representing the public interest in Act 250 proceedings. As I said earlier, with regard to some criteria, unless a citizen comes forward and presents information on it, there's no opportunity for the district commission to hear what impacts or how that criteria would be addressed. So in those circumstances, Act 250 proceedings, it's only the information from the applicant, and there's often no technical review as to whether that information is correct. And I would contrast this with Public Utility Commission proceedings, where there is very specifically participation of a public advocate, a statutory public advocate, within the Department of Public Service that is responsible for representing the public interest. I would recommend that there be provided a specific public advocate role for Act 250 proceedings that would be comparable to the public advocate in Public Utility Commission proceedings. And finally, concerning the administration in the proposal, there are some changes to the requirements regarding a stay pending appeal, and that just says that if there's an appeal going forward, the permit does not, the permit is stayed, is stopped, so you don't build while you're considering the appeal. These were eliminated in one section on page 52, but they remain in another section on 74, but that section is only for limited matters. So I think it needs to be clear that there's an automatic stay for all actions pending appeal. Thank you, that's all I have.
Thank you, that was a lot. Questions? Committee? Thank you very much.
Thank you.
Oh,
Wait, I have one question. Good afternoon.
Good afternoon.
My question is early on in your discussion when you talked about the enhanced board and how to make that more workable. And what we've contemplated here is, in order to maximize the value of the district commission level in hearing cases, is to have the case, should it end up in appeal, to go on the record appeal. And I'd love your opinion as to whether that's the value of doing that, and whether there are some any downsides that we should be aware of, such as maybe creating a more formal process that might in fact, the unintended consequence might in fact be creating yet another barrier for public participation.
Mm-hmm. Anytime, yeah, there's obviously balance there. Anytime you have an on-the-record review, it's going to need to be a more formal process. It needs to be a clear process for how you introduce evidence, how you consider that evidence. So that's going to be more difficult for citizens to participate. You already have a fairly difficult process for citizens to participate. The other side of that is you would be eliminating the second round of appeals. So you're not going through the process twice. What happens now is sometimes the initial proceeding, the proponent has an opportunity to just kind of sit back and see what others might have to say about their proposal. And whether they get denied or not, it doesn't matter. It goes forward on appeal anyway. On the other hand, the citizens, if they're participating at the district commission level, they have to put on a full case, because their entire standing and ability to participate and ability to appeal may rest on whether they've actually contributed to the consideration. So that also creates a burden for citizens. That's why I recommend that there be some, particular assistance, technical and legal assistance for citizens to participate if you're going to have an on-the-record review.
So, do you prefer one over the other? Professional board versus the sort of help, I want to say enhancing, but that's the wrong word because we're talking
Say
about
what?
supporting district commissions more so that they can do on the record versus a professional board.
I think either could work.
On mitigation, in your experience, does mitigation more or less resolve issues without taking them to court?
I don't know that mitigation resolves issues without taking them to court. Mitigation is a means to avoid or allow a permit to go forward, and you get to protect something somewhere else, but you destroy the resource in this particular area.
Mm-hmm. I'm just wondering if there was a question of more or less seeing it as a way to avoid the expense of appeals, legal appeals to the courts. But obviously not.
Representative
So I'm not sure if you were in the room this morning when I was espousing on mitigation being great in many circumstances, but not in this particular one. But I'm wondering if, because I do second guess myself, if you're aware of past case law that has, or situations where mitigation regarding habitat for species and plant and animal have been successful have been successful for those animals and plants. I mean, is it I mean, we were made aware of probably a very poor mitigation around Lowell Wind, and yeah, the bear habitat got a new lot in Long Island somewhere, and but it didn't really help them. But so are you aware of how mitigation has actually been successful in that arena?
Starting from the place that mitigation automatically allows the destruction of some natural resources in exchange for protection of some other, of that same natural resource somewhere else.
Right.
It never results in a net gain of protection, you're just destroying less. Sometimes there may be more valuable habitat somewhere else, and I guess it was before there was mitigation, but I think about, this was even before my time, when I was thinking when Killington expanded and there was a protection of Parker's Fort, which was a very valuable bear habitat in that area. That was under threat of some other development, and in exchange for protecting a much larger area of more valuable habitat, a more limited development was allowed to advance as part of the expansion at Killington.
Yeah.
So I think I would cite that as an example of where a type of mitigation has been successful.
And so I'm reaching for a way for me to better understand that and approve that kind of an idea. Were there sideboards put on that particular?
I think
or could there be?
There could be, and I think the Environmental Board a number of years ago put some pretty clear sideboards on the application of agricultural soils mitigation. It made it clear it should only be used as a last resort, and only after you've tried but failed to figure out how to propose a development to avoid the need for mitigation. There have been some changes to the rules since then, so that's not always applied that way, and in many circumstances their mitigation is fairly automatic. So I think there can be sideboards that you can put on mitigation to limit its application, and that would be helpful.
Yeah, thank you.
On your recommendation to eliminate all ridgeline development, would you include industrial turbines on that?
It's not to eliminate all ridgeline development, it's to require that all ridgeline development be considered a major development. So.
But they would have to, how would that work, and how would that change the present situation?
The wind projects are reviewed under Section 248 of the Public Utilities Commission, and they apply the Act 250 criteria in their proceeding.
Yeah, let's go follow up on that. So the 248 process uses the Act 250 criteria and has been around for quite some time, and that was specifically obviously used for siting of our transmission lines, for example, other utility projects. Now we're in the brave new world of major land use impacts associated with energy projects that are under the jurisdiction of Public Utility Commission. So it's the much bigger impact. Are we at a point in time where we should start thinking about an enhanced mechanism or a definite mechanism or a decision as to what part of an energy proposal should be managed through an Act 250 process versus a 248 process? Or would you have any recommendations on how to ensure that we are being mindful and wanting to avoid and minimize the impacts of these much more substantial projects that are causing much more substantial impact, especially in rural regions around the state?
many utility projects have involved significant impacts for a number of years, so I'm not sure the impacts are more severe now than they were. Actually, Vermont Yankee was built before there was 248, but that had and continues to have significant environmental impacts. Coventry landfill is another utility project with significant impacts. Transmission lines going up and down the state have had significant environmental impacts, and all have been reviewed through the 248 process with the application of the Act 250 criteria. I think some states separate the land use impacts from the utility impacts. I think it's certainly helpful to have one review, if you could, provide additional information to the Public Utilities Commission or additional guidance as to how those impacts should be considered, that could be helpful.
Other questions? Thank you. So committee, our next scheduled witness is not till 3, so I think we'll pick back up with Ellen. And 3 is a phone call. See who wants to do it at 3 and not before.
I can reach out to him and see if he would like to open it up.
No.
No, okay.
Who's
It's
that?
been a long time since I've seen her or him either,
Or you want to
but,
just start with that and then just leave it at 3?
and her name is Sandy.
Let's just leave it at 3. Start with Ellen. Leave it at 3. Thanks. All right. Thanks.
Thank you.
Sandy.
Thank you.
All right, committee. It's my thought that we would continue to go through, seems like the side by side with the language has been the most helpful. Take it from the top, meaning page 1, we did some major blocks before lunch break.